Good morning everyone. Today we will be going to discuss on the topic trial in section 138 of the Negotiable Instruments Act. In a common parlance, a cheque is a financial instrument in which it is written by its owner to order his bank to pay a certain sum to another person from his account. The Oxford Dictionary defines the term cheque as a written order to a bank to pay a stated sum from his account to a specified person. In legal arena, according to the Beckham's Law Dictionary, a cheque is a draft signed by the maker or drawer, drawn on a bank, payable on demand, and unlimited in negotiability. As far as India is concerned, the law which governs the cheque transaction is the Negotiable Instruments Act 1881. In the eyes of Indian law, a cheque is a bill of exchange drawn on a specified banker and not expressed to be payable otherwise on demand, and it includes the electronic image of a truncated cheque and the cheque in an electronic form. Notwithstanding the advent of the electronic transfer, a cheque transaction hasn't lost its popularity. It has become not only common but also a sine qua non in most of the commercial transactions. The apex court in Goa Plus Private Limited versus Chico Urzala D'Souza, wherein it held that Chapter 17 containing Section 138 to 142 was introduced by the Act 66 of 1988 with the object of inculcating faith in the efficiency of banking operation and giving credibility to the negotiable instruments in business transactions. These provisions were intended to discourage people from not honoring their commitment by way of payment through checks. The savior of victims, Section 138, is considered as a savior because it is in the absence of Section 138, the victims of dishonored cheque cases will only have an option to file a suit for recovery of money under the Civil Procedure Code 1908. And the victims will be subject to payment of stamp duty and sluggish civil procedures, but in the section imposes punishment in the nature of both imprisonment and fine. The maximum term of punishment that can be awarded under this act is 2 years of imprisonment or with a fine which may extend to twice the amount of the cheque or with both. Hence, the intention of lawmakers by bringing this section is to reduce the number of fraud committed in the cheque transaction to make fraudsters punished with an speedy justice. Section 138 read as follows. Dishonor of cheque for insufficiency of fund in the account. Were any cheque drawn by a person on account maintained by him with a banker for payment of any amount of money to another person from that account for the discharge, in whole or in part, of any debt or other liability, is returned by the bank unpaid, either because of the amount of money standing to the credit of that account is insufficient to honor the cheque, or that it exceeds the amount arranged to be paid for that account by an agreement made with that bank. Such person shall be deemed to have committed an offence and shall, without prejudice to any other provisions of this act, be punished with the imprisonment for which a term which may extend to 2 years, or with a fine which may extend to twice the amount of the cheque, or with both, provided that nothing contained in this section shall apply unless the cheque has been presented to the bank within a period of 6 months. Now it has been changed to 3 months from the date on which it is drawn, or within the period of its validity, whichever is earlier. The payee or the holder in due course of the cheque, as the case may be, makes a demand for payment of the said amount of money by giving a notice in writing to the drawer of the cheque within 30 days of the receipt of the information by him from the bank regarding the return of the cheque as unpaid. And the third one is, the drawer of the cheque fails to make the payment of the said amount of money to the payee, or as the case may be, to the holder in the due course of the cheque within 15 days of the receipt of the said notice. The explanation part says that for the purpose of this section, debt or other liability means a legally enforceable debt or other liability. Now, coming to the presumption in the cheque case, the concept of presumption can be first traced in the Indian Evidence Act, that is section 4 of the Act, which deals with three categories of presumptions. They are shall presume, may presume, and conclusive proofs. The first two categories of the presumptions are rebuttable in the contrary, and the last one is irrebuttable. In may presume, the court have wide scope either to presume the fact or not. So the presuming a fact is totally based on the course of discretion. In the case of shall presume, a court are obliged to presume a fact unless and until the fact is rebuttable. When it comes to a conclusive proof, there is no chance of rebutting the facts. The court shall not allow to adduce evidence to disallow when a fact is declared to be a conclusive proof of another by the other fact. Now, the presumption under section 118 of the Negotiable Instruments Act relates to the consideration, date, time of acceptance, time of transfer, order of endorsement, stamp, and holder in due course. The presumption under this section is inclusive and it includes all kinds of negotiable instruments. But section 139 of the negotiable instrument is exclusively for cheque cases. It deals with the presumption in favor of the holder of the cheque. In section 139, the Negotiable Instruments Act read as under: presumption in favor of holder. It shall be presumed unless the contrary is proved that the holder of a cheque received the cheque as a nature referred in section 138 for a discharge in whole or in part of a debt or other liability. From the above mentioned provisions of law, the court under this section should presume that the cheque has defined in section 138 have been received by the holder for a discharge of either in whole or in part of a debt or liability. As far as the interpretation of words any debt or liability is concerned, the court are guided by the explanatory provisions provided under section 138 of the Negotiable Instruments Act. The explanatory part of section 138 is as follows. For the purpose of this section, the debt or other liability means a legally enforceable debt or other liability. Therefore, the complainant cannot succeed unless either a debt or other liability is lawful. That is, the transaction should not violate the provisions of any law or the law which in time being in force. The Honorable Supreme Court held that the complaint under section 138 must contain the following ingredients: that there is a legally enforceable debt, that the cheque was drawn from the account of the bank for a discharge of whole or in part of any debt or other liability which possesses a legally enforceable debt. Thirdly, the cheque so issued should be returned due to insufficiency of fund. When it comes to a rebuttable presumption as contemplated under section 139, it depends on the facts and circumstances of each case. In the light of section 139, the action for rebutting the presumption would lie only in the hands of the accused. Hence, in all cheque cases, the onus initially lies on the accused, unlike in all criminal cases. In layman's point of view, cheque bounce cases are considered as criminal cases, but the very same nature of cheque bounce cases is a civil wrong coupled with the criminal provisions. In order to uphold the credibility and efficiency of the cheque, the transaction, and to ensure the speedy disposal of the cases, the lawmakers have incorporated the penal provisions. As a result, the cheque dishonor cases are driven by the doctrine which is called as preponderance of probabilities, which follows in the civil cases, and not the doctrine beyond reasonable doubt which follows in criminal trials. In Ans Rajshekhar versus Augustus Jabba Anand, the absence compelling justification reverse honest clause usually impose an evidentiary burden and not a persuasive burden. Keeping this in view, it is a settled position that when an accused has to rebut the presumption under section 139, the standard of proof for doing so is that the Preponderance of probabilities. Therefore, if the accused is able to raise a preponderance defense which creates a doubt about the existence of the legally enforceable debt or liability, the prosecution can fail. As a clarification in the citation, the accused can rely on the material submitted by the complainant in order to raise such a defense, and it is conceivable that in some cases the accused may not need to adduce evidence of his or her own. The Honorable Supreme Court in Bir Singh versus Mukesh Kumar held that even a blank check leaf voluntarily signed and handed over by the accused, which is towards some payment, would attract the presumption under Section 139 of the Negotiable Instruments Act, in the absence of any cogent evidence to show that the check was not issued in discharge of debt. Now, setting the law in motion, the check cases are consideration of both Negotiable Instrument and Criminal Procedure Code. As per Section 138 of the check has to be within a period of its validity based on the RBI notification. The period of validity has been reduced from 6 months to 3 months. The law set in motion by issued demand notice within a period of 30 days from the receipt of information by the payee or the holder in due course of the check, as the case may be, regarding the check as unpaid. If the drawer fails to remit the said amount within the 15 days of the receipt of the said notice, Section 142 comes into play. According to Section 142, the Court of Metropolitan Magistrate or a judicial magistrate of first class shall take cognizance of the offence enunciated under Section 138 only after filing a written complaint by the payee or the holder in due course of the check, provided that no court inferior to that of a metropolitan magistrate or a judicial first class magistrate has the authority to take the cognizance of the offence. The court may also condone the delay for filing the complaint under Section 5 of the Limitation Act. Indeed, the intention of the framers of Clause B of Section 142 is to give an opportunity to the complainant in case of any untoward situations. In Sadanandan Bharathan versus Mahadevan Sunil Kumar, the apex court held that consequent upon the failure of the drawer to pay the money within a period of 15 days as envisaged under the clause of the provision 138, the liability of the drawer from being prosecuted for the offence he has committed arise, as a period of 1 month for filing the complaint under Section 142 is to be reckoned accordingly. Now, with regards to the place of suing, in K. Bhaskaran versus Shankaran Vaitin Balan, it was held that in order to attract Section 138, the following components are essential. 1. Drawing of the check. Second one is the presentation of the check to the bank. Third, returning the check unpaid by the drawee bank. Fourth, giving notice in writing to the drawer of the check demanding payment of the check amount. First, failure of the drawer to make the payment within the 15 days of the receipt of the notice. If the 5 different acts were done in 5 different localities, any one of the courts exercising the jurisdiction in one of the 5 local areas can become the place of trial of the offence under Section 138. The 3-judge bench of the Supreme Court overruled the ratio decidendi and held that the place of suing is determined by the place where the offence was committed under Section 177 of the Criminal Procedure Code. Thus, the complainant is a statutory bound to comply with Section 177 of the CRPC, and therefore the place of suit where the Section 138 is to be filed is not of his choosing. The above mentioned judgments prevailed till the birth of the Negotiable Instruments Amendment Act 2015. After the insertion of Clause 2 of Section 142, the negotiable instrument, the issue of place of suing has been settled. As per the subsection 2 of Section 142, the offence under Section 138 shall be inquired into and tried only by the court within whose the local jurisdiction is. If the check is delivered for collection, through an account, the branch of bank where the payee or the holder in due course, as the case may be, maintains the account is situated, or if the check is presented for payment by the payee or the holder in due course, otherwise through an account, the branch of the drawee bank where the drawer maintains the account is situated. Proceeding in dishonored check cases. The initial proceedings, section 143 empowers the judicial magistrate of first class or metropolitan magistrate to try the case summarily as per the provisions of section 262 and 265 of the Criminal Procedure Code, and the magistrate under this section has the authority to pass the sentence of imprisonment for a term not exceeding 1 year and an amount of 5,000. If the magistrate apprehends that the sentence of imprisonment for a term exceeding 1 year may have to be passed for any other reason undesirable to the case summarily, the magistrate shall, after hearing or rehearing the parties and witness, shall record the reasons in writing and proceed in the manner stipulated in the code. For the mode of service, the magistrate may direct to serve the copy of the summons through speed post or courier service approved by the Court of Sessions, either at the place where the accused or the witness ordinarily resides or carries on his business or personally works for gain. In case of the refusal of the received, the court issuing summons may declare that the summons has been duly served. Cognizance without physical appearance. The essence of physical appearance has been diluted by section 145. This was done in order to render a speedy justice. Section 145 deals with receiving evidence on affidavit. For taking cognizance, it is not mandatory for a complainant to come in person to file the complaint. If the court is satisfied based on the application either by the prosecution or the accused, can issue subpoena and examine the person adducing the evidence on affidavit. The Supreme Court in Indian Bank Association versus Union of India held that the court has option of accepting affidavit of complaints and other witness instead of examining them in the court for their examination in chief. However, witness to a complainant and the accused must be available for cross-examination as and when there is a direction to effect by the court. In Ariplavan Finance versus State of Kerala and others, Justice B. Sudhindra Kumar held that it is abundantly clear from the object of the enactment of section 145 of the Negotiable Instruments Act and the ratio laid down by the Apex Code that the personal appearance of the complainant is not necessary for taking cognizance of the offence. Therefore, the court dealing with the case under section 138 of the Negotiable Instrument Act shall not insist for personal appearance of the complainant at pre-cognizance stage if the complainant is accompanied by affidavit of the complainant and the affidavit and the documents, if any, are found to be in order. This being the position, the dismissal of the complaint by the court below before taking cognizance on the reason that the complainant was not present in person before the court cannot be justified. From the above, it can be assumed that the court have an option to take cognizance of the offence without personal appearance of the complainant in the case of complaint accompanied by an affidavit. In Goa Plus Private Limited versus Chico Ursula D'Souza, the Apex Court held that the court should learn in favor of the interpretation which serves the object of the statute. The post-dated check will lose its credibility and acceptability if the payment can be stopped routinely. This reiterated the same position in Rangappa versus Sri Mohan. The Supreme Court feels that the defense of proof of fund after presumption is filthy one. In Rohit Bhai Jinwalal Patel versus State of Gujarat and others, the court held that needless to reiterate that the result of such presumption is that existence of a legally enforceable debt is to be presumed in favor of the complainant. When such presumption is drawn, the factor relating to the want of documentary evidence in the form of receipt or account or want of evidence as regards source of funds were not relevant consideration while examining if the accused has been able to rebut the presumption or not. The latest amendment in the Negotiable Instruments Act. The 2018 Amendment Bill faces some mixed reviews. Some said it is a bill for a money launderers, but the majority said the bill will bring down the unnecessary litigation. But Dr. Shashi Tharoor mentioned that the bill failed to give a space for a trial in absentia. The main focus of the bill was the interim compensation under Section 143A and 148. Section 143A and Section 148 have been inserted by virtue of the Negotiable Instruments Amendment Act 2018. The amendment deals with a concept called interim compensation. In pursuance of Section 143, if the accused pleads not guilty by the court, may order him to pay an interim compensation not exceeding 20% of the cheque amount. The accused has to pay the compensation within 60 days from the date of the order, which can be further extended to up to 30 days if the court is satisfied by the result. When the interim compensation remains unpaid, the same can be recovered as fine under Section 421 of the Criminal Procedure Code. The Section 421 of the Criminal Procedure Code 1973 read as follows. Warrant for levy of fine. 1. When an offender has been sentenced to pay fine, the court passing sentence may take action for recovery of fine either or both of the following ways. That is to say that it may issue a warrant for a levy of amount by attachment and sale of immovable property belonging to the offender. Secondly, issue a warrant to the collector of the district authorizing him to realize the amount of arrears of land revenue from the movable or immovable property or both of the defendant, provided that if the sentence directed that the default of payment is fine, the offender shall be imprisoned, and if such an offender had undergone the whole of such imprisonment in default, no court shall issue such warrant unless for a special reason to be recorded in writing. It considered it necessary so to do, or unless it has made an order for the payment of expenses or compensation out of fine under Section 357. Secondly, the state government may make rules regulating the manner in which warrant under clause A of subsection 1 are to be executed and for the summary determination of any claims made by a person other than the offender in respect of the property attached in execution of such warrant. Where the court issues a warrant to a collector under subclause B of subsection 1, the collector shall realize the amount in accordance with the law relating to recovery of arrears of land revenues, as if such warrant was certificate issued under such law, provided that no such warrant shall be executed by the arrest or detention in prison of the offender. In case of the acquittal, the complainant is bound to pay the interim compensation along with interest from the date of such order till the 60th day, which can be further extended to 30 days after showing sufficient cause. Section 148 relates to the payment of interim compensation in stage of appeal. In an appeal, the drawer against conviction under Section 138, the appellate court may order the appellant to deposit such amount which shall be a minimum of 20% of the fine or compensation awarded by the trial court, and it follows the same proposition laid down under Section 145A. Compounding provisions. According to Section 147, all offences which are punishable under this Act can be compounded. This section plays a major role in decreasing the pendency ratio. In the case of Jammu and Kashmir Industries Limited, the top court observed that in view of the non-obstant clause in Section 147 of the Act, requirement of the consent of the person compounding in section 320 of the CRPC is necessary even in case of compounding offence under the Negotiable Instruments Act, but the judgment didn't withstand for a long time. The judgment was overruled by the court in MS Meters and Instruments Private Limited and others versus Kunjan Mehta, wherein it is held that though compounding requires consent of both parties, even in the absence of such consent, the court, in the interest of justice, on being satisfied that the complaint has been duly compensated, can in its discretion close the proceeding and discharge the accused. Therefore, from the Meters and Instruments Private Limited and others, it can be inferred that if the court finds that the complaint is duly compensated, the court, in the interest of justice, the court have full power to close the trial without any concurrences. As a conclusion, we can say that it is very pathetic to hear besides all these developments, colossal check-bound case remain unsettled. The Law Commission in its report suggested for a constitution of fast-track magistrate courts to address the problem of pendency of dishonored check cases. The report says over 38 lakh cases remain unresolved across all over India. As per Times Now report, Law and Justice Minister Ravi Shankar Prasad said that the government is working for bringing a fast-track court mechanism for dishonor of cheque. The Honorable Supreme Court, by virtue of its law-making power, as given in the Constitution, provided many directions in the cantina of cases in order to a speedy trial. Now it is left to the legislator to make the Act more vibrant in the upcoming times. Thank you.